Madam. Avneet, over to you.
Good evening, sir. With your kind permission, can we start, sir?
Please.
Good evening to everyone present here. I, Avneet Kaur, delegate of Sambhav Initiative and moderator of this event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Sri Arijit Prasad, sir, and to all the participants in this fifth day of 15 days online national capacity building program on land, real estate, and property laws, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, mental health, and creating legal literacy. Organized this program under the vision of Patron in Chief of Sambhav Initiative, Honorable Mr. Justice C.K. Thakkar, sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Mr. Justice M.R. Shah, sir, former Judge of Supreme Court of India, and Pro Bono India, which is working towards legal literacy and legal aid. Where today's session is all about career perspective in revenue and civil law practice. Before we start the session, please adhere to some webinar etiquettes. I request all the attendees to keep their microphones muted during the session. If you have any questions, please use the chat box or raise your hands. It is my privilege to introduce our esteemed dignitary, Sri Arijit Prasad, sir, Senior Advocate, Supreme Court of India. Arijit sir is a distinguished senior advocate designated by Honorable Supreme Court of India in March 2019 with over 26 years of extensive experience in direct tax, indirect tax and commercial litigation. Sir has appeared in more than 400 reported landmark cases before the Supreme Court and has represented several Indian states including Andhra Pradesh, Chhattisgarh, Gujarat, Haryana, Maharashtra, Rajasthan, Uttar Pradesh, Tripura, and Tamil Nadu. Sir holds an LLM merit in corporate and commercial laws, including international arbitration from London School of Economics, and is qualified as a solicitor entitled to practice in England and Wales in 2003. Sir earned his BCom honors and LLB from Delhi University in 1996 and 1999 respectively. Sir was appointed as special counsel for tax matters for the Union of India before the Supreme Court during 2013 to 2014, receiving remuneration equivalent to that of an additional Solicitor General. Sir also served as Senior Standing Counsel Income Tax before the Delhi High Court in 2008 to 2009. Sir is empaneled as Panel A Counsel for the Union of India in the Supreme Court since 2004 and has regularly rendered legal opinions and represented numerous multinational corporations, including through Magic Circle law firms based in London, as well as top tier Indian law firms and big four accounting firms. A respected member of legal fraternity, Sir has been elected 4 times as senior executive member of the Supreme Court Bar Association, securing the highest votes and margins in the most recent terms in 2019 to 2025. We are deeply honored to have you with us today, sir. Over to you, sir.
Thank you very much. Really good to hear Sambhav initiative starting such a big program for 15 days. I'm sure that such a program would help all the law students, aspiring lawyers, and young lawyers hearing from people across the country. It's a really a privilege, and I'm really proud to be here before you. So my topic that has been given to me by Iranshi and Dr. Kalpesh is career perspective in revenue and civil law practice in contemporary India. Now, land is the stage upon which all human drama unfolds. To understand law, one must first understand land. Today's keynote is not merely about a career direction, it's a deep dive into the tectonic changes sweeping through revenue and civil law practice in India. From urban real estate frauds in Noida to title mutation conflicts in Bihar, from family property partitions to blockchain-based land registration, this field is becoming one of the most lucrative practices and intellectually stimulating areas in the legal field today. Why revenue and civil law practice matters. Historical foundations. Land law was the first regulatory framework imposed during colonial law. Permanent Settlement Bengal Act of 1793, the Royatwari Madras, Mahalwari Punjab, post-independence Zamindari Abolition Acts laid the foundation of the agrarian reforms. Constitution linkages. Now, Article 300A, no person shall be deprived of his property save by the authority of law. Article 39B, distribution of material resources for the common good. Entry 18, state list. Land is a state subject. Variation in laws and forums across India. Contemporary relevance. Disputes over possession, inheritance, developmental rights, mutation, delays, and compensation claims are routine. These kind of conflicts can be seen from the lowermost adjudicating authorities and going up to the Supreme Court. Anybody who starts his legal practice gets to get matters of these kind. Anybody in the family who is a lawyer would be asked, you have become a lawyer, get us a will made. Similarly, similarly, you have various other land disputes, partition suits. So these are kind of areas which are very common. And when a person becomes a lawyer, he easily gets matters of this kind. Therefore, this is an area which is very lucrative, and anybody and everybody who becomes a lawyer should strive and should know these areas. Now, about the contemporary relevance of revenue and land laws, dispute over possession, inheritance, developmental rights, mutation delays, compensation claims. These are very routine matters. And these kind of matters come to lawyers very early when they become lawyers and when their family and friends know that somebody has become a lawyer. Real estate today contributes over 7% to GDP, expected to rise to 13% by 2030. Therefore, one can understand kind of matters that would be generated and the matters that lawyers who are in these fields would know. I mean, you have land disputes, you have uh, land building owners, you have builders, you have people who go and book flats. Now, RERA is an area where people book flats and there's delay in construction, there's delay in handing over flats to the flat buyers. This is a very lucrative area. Young lawyers who are very nascent in the stage of the profession get matters of this kind. Very important and very much available everywhere. Similarly, you have the NCLT, where big builders become insolvent. They go for CIB processes, and multiple litigation starts, and young lawyers get a toehold appearing for flat buyers in these particular forums. These matters go all the way up to from NCLT, NCLT, the Supreme Court. Now, the urban explosion of land disputes focus has been in Noida, Gurgaon, Hyderabad, and every other metro city and the cities they are coming up. These urban centers now generate multi-jurisdictional, multi-stakeholder disputes. Core issues that generally come up for lawyers are super built-up area manipulation done by the builders when they offer you a flat, super built-up area, carpet area. People talk about various fine prints in their documentation, but people who go to buy the flats are not aware. They're given a huge booklet and they are supposed to sign the paper. Now, when the flats are later on given back, they have huge problems, and these all go to litigation. Super built-up area manipulation refers to a deceptive practice in the real estate sector. The developers inflate the total area of a property by including non-usable spaces, thereby misleading buyers about the actual size of the unit they are purchasing. The super built-up area includes the carpet area, that which is the actual usable space inside the apartment, and the built-up area, carpet area plus walls and balconies. Also adds common areas like lobbies, staircases, lifts, gymnasiums, and clubhouses. Manipulation occurs when developers disproportionately allocate small common areas to individual units or include amenities that are not equally accessible or functional for all residents. This leads to a significant discrepancy between what buyers believe they are paying for and the actual livable space they receive. For example, a buyer might be told they're purchasing a 1200 square feet apartment. The carpet area, that is the usual usable part, might only be 700 square feet, the rest being non-exclusive shared space. This practice allows builders to charge higher rates based on inflated square footage, increasing their profits while delivering less value to customers. It also complicates price comparisons between properties, as some developers may provide more transparent measurements. Example, based on carpet area, while others rely on the inflated super built up. These kind of manipulations which the builders undertake, the lawyer should be aware. A lawyer should be able to distinguish so that they can advise their clients effectively. The Real Estate Regulation and Development Act 2016, more commonly known as the RERA, in India has taken steps to address this by mandating that developers disclose the carpet area separately and base pricing. However, in markets where regulation is weak or enforcement is lax, super built up area manipulation remains a concern. For home buyers, understanding the difference between carpet built up and super built up area is critical to making informed decisions and avoiding overpayment for less usability. This is very, very important, and even the new lawyers who take up these cases should be aware about the technical aspects of it. Now we come to case law. DLF Universal Limited versus Bel Air Owners Association in 2010. CCI held that DILF guilty of abuse of dominant position for unilateral changes in the project. FSI and zoning violations. FSI or Floor Space Index is not just a technical formula. It's a policy tool that shapes our cities. It controls how much can be built on a plot, ensuring balanced development and protecting public infrastructure. But when builders exceed this limit, often in collusion or through manipulation, it results in overcrowding, poor ventilation, and unsafe structures. Zoning violations are equally serious. Imagine a residential area where a commercial mall suddenly emerges. Traffic, noise, and strain on basic amenities follow. These aren't just legal breaches, they're violation of public trust and urban planning. As lawyers, urban advisors, or policymakers, we must ensure that development respects legal boundaries, complies with FSI, and zoning isn't a bureaucratic hurdle, is essential for livable, sustainable cities. Let us commit to a legal practice that doesn't just win cases but protects the fabric of our neighborhoods. More case law to follow. Isha Ekta Apartment Cooperative Housing Society versus Municipal Corporation of Mumbai. Unauthorized floors ordered to be demolished. Held, buyers cannot claim equity if the construction itself was illegal. This is very important because the buyers are not aware about violations and they fall into deep trouble when these unauthorized constructions are demolished. Takeaways. Always advise clients to obtain approved plan copy. An approved plan copy is a legally sanctioned layout of the building or the project authorized by the local municipal authority or planning department. It includes details such as the building's dimensions, number of floors, usage, whether it's a residential area, commercial area, the location of amenities and open spaces. Purpose ensures that the constructions follows the local zoning laws and the building codes. Why is important? It's important because buying property without an approved plan increases the risk of demolition of penalties due to illegal or unauthorized construction. In fact, I remember there's a place just near the Supreme Court on the Barakham road itself. There's a place for the White House where the approved plan was 9 floors and the builder made 11 floors, and finally it was ordered to be demolished. And when a demolition of this kind happens, I mean, there is huge difficulty for the people who buy it, as well as when it's demolished, you have environmental problems and hazards as well. Occupancy certificate. The occupancy certificate is issued by the local municipal body after construction is completed. It certifies that a building is ready for occupation and has been built according to the approved plans with all necessary clearances, fire safety, sanitation, electricity, etc. Purpose indicates that the property is safe and legally fit to be occupied. Why is it important? Because without an OC, the property is considered illegal for residential or commercial use. It can cause issues with utility connections and property resale. Environmental clearance. Environmental clearance is again a very important clearance which is required for properties which are being constructed. Environmental clearance is a document granted by the Ministry of Environment, Forest and Climate Change or state level authorities for large or environmentally sensitive goods. It assesses the project's impact on the environment, including biodiversity, ensures that the construction does not harm the surrounding environment, and complies with the environmental laws. It's important because projects without environmental clearance may face legal hurdles, delays, or shutdowns. It's mandatory for large developments and those ecologically sensitive. Otherwise, these properties are also liable to be demolished, like anything which is constructed near the sea or the area which is very sensitive near the sea within 100 meters, which was earlier 100 meters, now being extended 500 meters, are also liable to be demolished, as it happened somewhere in Kerala. Some properties were being developed very close to the eco-sensitive zones, and which were finally ordered by the Supreme Court. Therefore, people who buy these properties should be made mindful of these hazards. Fake titles, multiple registrations are a hazard everywhere. There are people who are trying to make a quick buck by faking titles and doing multiple registrations. These kind of frauds are very prevalent and one must be aware and should be very careful buying properties. Fake titles refer to a forged or falsified ownership document that claim a person owns a property when they legally do not. This can involve the use of counterfeit title deeds, fake signatures, or tempered land records. These are used to deceive buyers into purchasing property from someone who has no legal right to sell it. Buyers may lose both money and property rights if the true owner reclaims the land. Therefore, it's important that a buyer always conducts a thorough title verification through a lawyer or requests an encumbrance certificate to confirm the ownership history of the property. Multiple registrations occur.
Sir, sorry to interpret in between. Your voice is coming and going. It's fluctuated.
Is it?
Sir, your voice is fluctuated, so we are not able to hear you properly.
Okay. If it fluctuates again, you do let me know.
Yes, sir.
Because the internet connection is showing stable. Okay.
Yes, sir.
So fake titles, multiple registrations, POSLs. Is it okay now?
Yes, sir, it is so.
Fake titles refer to forged or falsified ownership documents that claim a person owns a property when they legally do not. This can involve the use of counterfeit title deeds, fake signatures, or tempered land records, used to deceive buyers into purchasing property from someone who has no legal right to it. Buyers may lose both money and property rights. The true owner reclaims the land. Always conduct a thorough title verification through a lawyer or request an encumbrance certificate to confirm ownership history. Multiple registrations occur. The same property is fraudulently sold to multiple buyers, each receiving a valid looking registration document. The scammers profit by illegally selling a single property to more than one person. Legal dispute, court cases, and potential financial loss for unsuspecting buyers result from these kind of multiple registrations. Therefore, it is always advisable to conduct a title search, verify the encumbrance certificate, and ensure that the sale deed is registered only once with the sale sub-registrar. POA sales involves selling property using a power of attorney where one person authorizes another to act on their behalf. While legal in specific cases like for NRI owners, it is often misused. Purpose sometimes used to bypass proper legal scrutiny, avoid stamp duty, or conceal legal ownership. If the power of attorney is forged, revoked, or not legally valid, the sale can be declared void. Prevention: check that the power of attorney is registered, current, and specific to the transaction. Ideally, insist on a sale by the legal owner directly. Common frauds: multiple sale of the same plot by using power of attorney, forged sale deeds. Gurugram and Greater Noida cases involve almost 200 plus duped buyers versus fake POAs. Now, recently, there are regulations and there are judgments against sale by power of attorneys. Now, the law involved Section 17 and 49 of the Registration Act 1908, Transfer of Property Act 1882. Section 17 says documents that must be registered. This section specifies the type of documents that must be compulsorily registered to have a legal validity. Key documents include sale deeds, gift deeds of immovable property, lease agreements for more than 12 months, instruments of partition, mortgage, or transfer of property, purpose to ensure transparency and legal recognition of property transactions. In fact, if a required document is not registered under Section 17, the transaction is not legally enforceable. Therefore, these are things which the young lawyers must be mindful of when they are undertaking a transaction, a conveyance deed, or advising their clients. Section 49, effect of non-registration of documents. Section 49 outlines the consequences if a document that must be registered as per Section 17 is not registered. I'll only give you the key points so that you can remember what are the main sections that one must go through while conducting a conveyance or going through a transaction of this nature. Key points: such a document cannot be used as evidence in court to prove ownership or transfer. It will not affect any immovable property or confer any rights over it. It is inadmissible for legal enforcement except in limited cases. Conclusion: failure to register critical documents makes them legally ineffective and unenforceable, and the lawyer himself would be shown in very poor light if the transaction fails and there are difficulties faced by the clients themselves. Now, the Transfer of Property Act is a very important act so far as uh, transfer of property is concerned. It governs the transfer of property in between living persons. Key features: applies to the sale, gift, mortgage, lease, and exchange of property. This defines who can transfer property and under what conditions, specifies that the transfer must be made by a person competent to contract and who has the right over the property. Purpose is to provide a legal framework for fair, valid, and enforceable property rights and ensures clarity of ownership and helps resolve disputes in property transactions. This Transfer of Property Act is a very important piece of legislation. One must know it very well for not only land matters, revenue matters, but for other important laws like income tax and all. Now, suppose there is a tripartite agreement where a landowner gives a property for construction, and there are other buyers who buys the property from the developer. Various regulations come into being, and people should be aware of it. For an example, if there's a transfer of property, which is not a transfer, but only for the purpose of construction, when the possession is to be taken later on, and there is a deposit made, income tax says such is not going to be income as a tax, not tax as an income. Suppose the property also possession is transferred along with this documentation, then this deposit becomes taxable in the year of the documentation. So Transfer of Property Act is a very important act. Therefore, people practicing not only in revenue and land cases, but even other areas like income tax, it has an aspect uh, in the various taxability of a person's. Now, the important judgments in this area are Suraj Lamp and Industries versus State of Haryana. It's a 2012 judgment which has held that GPA sales are not valid conveyance. Now we come to the builder insolvency and NCLT filings. Now this is a very important area. A lot of young lawyers get a lot of cases from home buyers when the flats are delayed or the builder goes into CIRP, that's insolvency. Now, builder insolvency refers to a situation where a real estate developer or builder is financially unable to pay debts or complete ongoing projects. This typically occurs when the builder runs out of funds, fails to repay loans to banks or financial institutions, or cannot make payment obligation to vendors, contractors, or home buyers. Causes of insolvency: delays in approvals of sales, market slowdown, mismanagement or diversion of funds, high debt burden, impact on home buyers. Construction halls project gets abandoned, long legal battle to recover invested money, emotional and financial distresses. NCLT filings, and that's NCLT means National Company Law Tribunal. Now, NCLT is a quasi-judicial authority in India that handles cases related to corporate insolvency under the Insolvency and Bankruptcy Code of 2016. It's a very important piece of legislation. This has been brought in to revive the companies who are not able to continue as a going concern. The aim of the particular act of insolvency and bankruptcy is maximization of value and to have the company as a going concern. Now, what happens when a builder is taken to NCLT? Creditors, including home buyers, after the 2018 amendment, can file an insolvency petition under Article 7, Section 7 or Section 9 of the IBC. If admitted, the NCLT appoints a resolution professional to take over the builder's operations. Now, this resolution professional, even a lawyer can give an exam after 10 years of professional practice and become an RP. The RP basically runs the company till the time a successful resolution applicant is appointed who would take forward the company thereafter once the debt of the company is resolved. Now, if admitted, the NCLT appoints a resolution professional to take over the builder's operations. The builder's assets are revised. The builder's assets are reviewed and a resolution plan is invited from other developers or investors. If no plan is approved, the builder may go into liquidation, where assets are sold to repay debts. For home buyers, recognized as financial creditors with voting rights in the committee of creditors, whatever the COC decides, it is the kind of a Lakshman Rekha. I mean, their wisdom is upheld even by the NCLT for any kind of plan which is resolved. The home buyers can claim refund of possession and part of the insolvency process. However, delays are common and outcomes are not guaranteed. Now, buyers are now treated as financial creditors under Section 5F of the IBC Law of 2016. The case law involved here are Pioneer Urban Land versus Union of India. Citation is 2019 SCC 416. Home buyers are financial creditors and can initiate CIRP. These are judgments which I have referred to, which the young lawyers should read so as to have a good idea about how, are the laws being developed, and they have a basic idea of this particular area of law. Forums. The phrase forums galore perfectly captures the current legal landscape in real estate and consumer dispute, where aggrieved parties find themselves navigating a multiplication of multiple forums. The areas have multiplied recently. They are RERA, Consumer Court, Civil Court, NCLT, and High Court, often for the same issue. When there is a fight between a builder and a home buyer, these are the various forums where the lawyer can go and get their resolve and when the disputes are resolved. Now, while each forum serves a distinct purpose, this overlapping jurisdiction creates confusion, delay, and forum shopping. For instance, should a home buyer approach RERA for possession, Consumer Court for compensation, or NCLT if the builder is insolvent? And what if all three apply simultaneously? This multiplicity often benefits the wrongdoer and burdens the genuine litigant. Jurisdiction clarity is not just a legal technicality, it's a question of access to timely justice. The need of the hour is harmonization and clarity, a streamlined legal framework when the roles of each forum are well defined and respected, reducing duplication and speeding up resolution. In this sea of forums, let us not forget the ultimate goal is justice for the buyer and accountability for the builder. Now, what happens is a person takes a loan, gives his money to the builder, hoping that he would get a flat for him to stay. But what happens is either the construction is delayed, money is embezzled, project doesn't take off, and the person, the home buyer, is saddled with the burden of paying the loan, the interest, and he doesn't have a house, the rent where he's staying. So this is an area which helps not the lawyers only to have a area of practice, but helps them to give some kind of service to the community as well. Now, a single real estate issue may touch various authorities. RERA authority for project delays and misrepresentation. The RERA authority established under the Real Estate Regulation and Development Act of 2016. For years, home buyers struggled with project delays, false promises, and a complete lack of transparency. The real estate sector was unregulated and buyers had little recourse. That changed with the introduction of RERA, a bold step by the government to bring accountability, transparency, and fairness into the real estate transactions. The RERA authority plays a crucial role. It ensures that all real estate projects are registered, that buyers disclose accurate information, and that home buyers are protected from fraud and delay. It mandates that 70% of buyers' money is kept in a separate escrow account, ensuring that funds are used for the same project. There were instances earlier when the buyers' money was taken by the builders and the money was embezzled or taken into various different other areas which the builders tried to develop. But more than just regulation, RERA gives voice and power to home buyers. If a builder delays possession, misuses funds, or fails to deliver as promised, buyers can file complaints directly with RERA and expect timely redressal. This isn't about rules, it's about restoring trust in the real estate market. Of course, challenges remain in implementation and awareness, but the message is clear that the era of builder impunity is over and the age of responsible development has begun. Now you have the NCLT. If the buyer goes insolvent, if the builder goes insolvent, the National Company Law Tribunal, if a builder goes insolvent and cannot complete a project or repay dues, buyers can approach the NCLT under the Insolvency and Bankruptcy Code. This forum appoints a resolution professional to recover or rescue the project. It's about protecting financial rights when a builder fails financially. One goes to the civil court for title and possession issues. The civil courts are the guardian of ownership. There is a dispute about title or a conflict about possession, civil courts have jurisdiction. These are long-standing matters. Ownership must be determined by evidence and law. Consumer forum for deficiency of service. The High Court, especially important cases involving government land allotments, lease violations, or public authority actions. These are often constitutional administrative issues needing judicial intervention at a higher level. NGT, one goes for environment violations, for concerns about environmental violation, illegal construction, eco-sensitive zones, or pollution from a project. The right place is the National Green Tribunal. This forum protects not just our homes, but our environment. In conclusion, knowing these forums and their functions saves time, energy, and often peace of mind. Let's stay informed because justice starts with knowing where to knock. And when the lawyers know about these issues and the forums where one can go and redress the client's issues, I mean, they can do it more efficiently and effectively. Skills for lawyers. As legal professionals, we often believe that our knowledge of statutes and case law is what defines our capability. While that's essential today, I want to highlight a few critical practical skills that every lawyer must master, especially in complex world of dispute resolution. First and foremost, the ability to map a dispute to the correct forum. The variety of forums, civil courts, consumer commissions, NCLT, RERA, NGT, and many more. Choosing the right one is not just strategic, it's essential. A well-mapped legal path can save clients years of litigation and thousands in legal costs. Closely tied to this is the need to avoid forum shopping. Clients often come to us wanting faster results. asking if you can file in different forums simultaneously. But as professionals, we must guide them responsibly. Courts frown upon forum shopping and it can lead to dismissals, penalties, or worse, loss of credibility of the lawyer. Choosing the wrong forum deliberately isn't clever, it's costly. Finally, we must master procedural doctrines like res judicata and constructive res judicata as laid out in Section 11 of the Civil Procedure Code. These doctrines prevent relitigation of issues already decided. If a matter has been heard and finally decided, it cannot be raised again. Constructive res judicata goes further. If you could have raised a point in the first suit and didn't, you're barred from raising it. This encourages finality and judicial efficiency, values we must uphold. In conclusion, being a successful lawyer is not just about winning arguments, it's about choosing battles wisely, respecting judicial boundaries, and guiding clients with clarity and integrity. Now, some of the important cases which lawyers should know about is MCD versus State of India. This is 2005-7 Supreme Court cases 278. It specifically has held that the litigants cannot take parallel reliefs in multiple forums. Now, rise of mediation in property and civil disputes. Today, I want to highlight a powerful and growing trend in the resolution of property and civil disputes, the rise of mediation. The legal system often overwhelmed by delays and complex procedures, mediation offers a faster, cost-effective, and amicable way to settle disputes. Recognizing its importance, the Supreme Court of India has taken proactive steps to encourage mediation. One such initiative is the Samadhan scheme, which mandates pre-litigation mediation for certain disputes. This means before a case even reaches the courtroom, parties are encouraged to sit together, communicate openly, and seek mutually agreeable solutions. Further strengthening this framework is the Mediation Bill of 23, which proposes the establishment of the Mediation Council of India. This council will oversee mediation standards, accreditation of mediators, and promote awareness, making mediation a more reliable and structured alternative. The success of mediation is evident. Take the Delhi Mediation Center, for example, which boasts a remarkable 70% success rate in resolving partition and property disputes. Such figures highlight mediation's ability to preserve relationships, reduce costs, and deliver timely justice. In a country where property disputes can drag on for years, mediation offers hope, transforming conflict into cooperation. Let us embrace mediation as a vital tool in our justice delivery system and encourage its wider adoption for the benefit of all stakeholders. Now, I would like to talk briefly about the Samadhan scheme, a significant initiative by the Supreme Court of India aimed at reducing the burden of courts and promoting early resolution of disputes. Under this scheme, pre-litigation mediation is now mandatory for certain civil and property disputes. This means that before a party files a lawsuit, they must attempt to resolve the issues. The goal is to encourage dialogue, cooperation, and settlement without the lengthy and expensive courts. The Samadhan scheme not only saves time and legal costs, but also helps preserve relationships by fostering unique solutions, reflects a shift towards a more efficient and people-friendly justice system. By mandating mediation before litigation, the scheme ensures that courts are left to deal with truly contested cases, improving the overall speed and quality of the justice delivery system. In short, the Samadhan scheme is a positive step towards making it faster, cheaper, and less adversarial. Now, some career tips to the young lawyers. If you are looking to build a successful career in mediation, here are first essential steps. First, get a certification in mediation. Formal certification not only boosts your credibility, but also equips you with the practical skills needed to handle complex disputes professionally. Second, focus on mastering key skills, such as understanding the consent terms, drafting clear and foreseeable settlement memorandums, and including important clauses like phase possession in the property dispute. This skill ensures that agreements are fair, comprehensive, and legally sound, helping parties reach lasting resolution. In today's world where alternative dispute resolution is growing rapidly, become proficient in these areas can also set you apart as a trusted and effective. The Supreme Court also runs a mediation program, and young lawyers who are in this particular program can look forward and apply and get their certification from the Supreme Court supported mediation. Now, career roadmap for young lawyers. It's a pleasure to speak with you today about some of the most important facets of property and civil law that every young lawyer must understand, starting from landmark judgments to technological transformation in land laws, followed by a career roadmap and emerging trends that are shaping the legal landscape in India. Some landmark judgments young lawyers must know are DLF versus Manmohan Law 2015. In this case, the National Consumer Dispute Redressal Commission held that the builder's failure to deliver a flat amounts to an unfair trade practice under the Consumer Protection Act of 1986, specifically invoking Section 21R. This judgment is crucial because it clarifies consumer forums remain accessible and relevant even after the enactment of RERA. For young lawyers, this means understanding the dual avenues for buyers, both under RERA and consumer protection laws. One must truly apply its mind to see whether one should go to RERA or to the consumer dispute redressal forums. Then you have Vidya Devi versus State of Himachal Pradesh. The Supreme Court decision held that the government's act of acquiring private land without proper compensation is unconstitutional, invoking Article 300A of the Constitution, affirming the doctrine of eminent domain. The takeaway here is the government acquisitions are subject to strict constitutional limits governed by laws such as right to fair compensation and transparency in legal acquisition act 2013. Young lawyers must be well versed in this statutory protection to advise clients. Sarbamati Devi versus Usha Devi. This judgment clarified that when a nominee holds property, they do in trust for the other legal heirs who are real owners. The case highlights the importance of understanding the interaction between the Insurance Act and the Succession Act, specifically Section 30, which is essential when dealing the property succession issues involving insurance policies. L&T and Housing Finance Limited versus Ishul Developers. A very significant ruling where the Supreme Court stated that in insolvency cases, buyers' interests rank higher than financial creditors concerning unsold inventory. This is a must-know case for civil lawyers as it emphasizes the importance of mastering the insolvency and bankruptcy code, especially the provisions related to moratorium under Section 14 to protect the buyer's rights. Rajasthan Housing Board versus Shivraj Singh. The court held that the specific performance is a discretionary remedy governed by Section 20 of the Specific Relief Act of 1963. This reminds us that while buyers often seek specific performance to compel a builder to deliver property, courts weigh the facts and may refuse it on empirical grounds. Understanding this discretion is key when advising clients on litigation strategy. And now the Specific Relief Act has been amended in 2018, and thereafter the ramifications thereafter now changed. So one must look at the amendments which has been brought out in particular act. Now, technology and transformation, digital India and land laws. Now, the legal field, especially property law, is undergoing a technological revolution. Digitization of land records and emerging technologies are transforming how lawyers work and how disputes are resolved. Now, Digital Land Records Modernization Program, the government's initiative has modernized land records by enabling online mutation, record inspection, integrating Aadhaar, and GIS mapping for accuracy and transparency. For lawyers, this means faster access to lawyers, better data verification, which is crucial, due diligence. Blockchain pilots in Maharashtra. Several states are experimenting with blockchain technology to create immutable land records and e-lockers. Blockchain's tamper-proof nature promises to reduce fraud and improve title security, a game changer for property laws. Lawyers must stay updated on these pilots and advise client accordingly. Lawyers' role in technological transformation, drafting smart contracts to automate and secure property transaction, advising clients on e-risks and digital fraud prevention, performing due diligence using online encumbrance portals and digital records. Career roadmap for young lawyers: you must master the core statutes, which are the Civil Procedure Code, Transfer of Property Act, Registration Act, Limitation Act, State Revenue codes. Strong grip on these laws form the backbone of your practice. Learn the art of purposeful drafting. Partition suits with genealogy charts to clarify ownerships. Injunction applications under 39 CPC to secure interim relief. Sale deeds including crucial indemnity clauses. Mutation applications and appeals for seamless property transfer. Drafting is not just paperwork. Your drafting should be advocacy in the written form. Therefore, drafting should be such that the judge adjudicating should know about your case only by reading it, and you get a notice issued without you having to really argue your case out. You can expand into your allied domains. environmental law, coastal regulation, zones, forest rights, urban planning, building bylaws, developmental control regulations, corporate finance, land mortgages, asset securitization, alternative dispute resolution, mediation. Emerging trends to watch: litigation in SEZs and land banks, land use conflict, title tech litigation. For young lawyers, these professions help bridge the gap between traditional lawyering and technology. They ensure that digital land records are accurate and secure. Final thoughts: the lawyer as a landscape architect. As lawyers in property and civil law are more than just legal representatives, we are landscape architects, shaping communities, enabling families to resolve decade-old disputes, and supporting infrastructure development that defines the skylines. This field is rich in complexity and impact. Don't view it as a fallback, but as a frontline career with vast potential to influence society. I'll leave you with this powerful thought: justice is not a mystical force, it's a map. Lawyers are its cartographers. Thank you for your attention. I hope this journey through judgments, technology, career guidance, and emerging trends inspires you to explore and excel in this fascinating domain. I wish you guys all the best and hope you have a flourishing career ahead. Thank you very much. Namaskar.
Thank you so much, sir, for this wonderful, I can say, session. In a, I can say, short span of time, you explain majority of landmark judgments and throughout the various statutes which all young lawyers should know about. So now we open the floor for
I thought let me try within the time
yes,
given to
sir.
give you as much as possible in
Yes,
a
sir. It's
capsule.
a very fruitful session, and we learned a lot from it, sir. Thank you, sir.
Thank you, Hiranshi. Thank you, Dr.
Yes. Now we open the floor for question and answer. Whosoever have any question, now you can unmute yourself and raise your hand and ask question to the sir.
There are
Over to
question in the chat box, three, four questions. So what are the points to be kept in mind when choosing the right forum?
You must look at your facts and you must look how the act helps you out. Is going to be giving your clients justice within the shortest possible time. It all depends upon the facts that you have, because you should be the master of your facts, and the law is applied to a fact. Therefore, you have to see how your facts help your client effectively and the shorter point in time.
Another question, sir, you suggested that there is a need of harmonious construction between Consumer Act, RERA, and NCLT. Could you please put some light on the same, like what can be done?
It all depends on how and what kind of a builder you have made the purchase of your flat. Suppose now a builder who has delayed the giving of your flat is in economic distress. He is not able to make payments to his vendors, and they are litigation being initiated for his corporate insolvency. Then you must also become a co-applicant, get yourself included, be part of the COC, and determine how and what kind of a SRA, that is successful resolution applicant, gets the project so that you can, at a short point in time, complete your project. Somebody who has the requisite knowledge as well as the finances. In such a scenario, you go to a forum which is like NCLT. But if there is only a deficiency of service, your particular builder is in good financial health, and because of other reasons he has not given you the delivery of your flat in time, you can go to consumer forum, you can go to RERA also. One difficulty with RERA is that they do not have any power, force to comply with their orders, which your National Consumer Forum has. Contempt powers, the police power. So you have to see what is the facts.
Another question, what kind of, sorry, what are the types of cases under revenue and civil law which a lawyer can practice both being a litigation and non-litigation matters?
See, all cases go to court are litigation courses. And when people come to you, clients come to you before going to litigation, those are your chamber practice or opinion. And there are also cases where you are asked to give a write a will, where I asked to write a gift deed, You do conveyancing, agreement of sale. Those are more of a pre-litigation stage where you are asked to do timber practice, conveyancing kind of a thing. And when these kind of dispute arises in this kind of instruments, then you go to litigation. So therefore, you should be knowing the law. If you know the law, these areas you can perform whether it's advisory work or litigation work.
Another question, why is there is the issue of insolvency when RERA stipulates the mandate for escrow account for builders?
These amendments have taken place now, but there are a lot of projects which started way back, and particular laws were not stringent or not, and the builders were taking the buyers for a ride. So these are things which have fallen into place. RERA has come later on. These amendments have come later on. So as the government and the authorities are becoming wiser, they're trying to plug the loophole which existed before well in time.
Let's throw some light on TDR, transferable development rights.
Transferable developmental rights.
Yes, yes, yes.
Transferable developmental rights are suppose there is a company has a subsidiary. That company has another subsidiary. Uh, the company may not have the rights to the development of a project yourself. They would take the development rights from its subsidiary company. That is one. Sometimes it so happens that the company who has the rights of development doesn't have the requisite finances. There it may get amalgamated to a different company, or it may so happen that it may sell transfer the rights of the development to a company which is cash rich.
So another question, any light on arbitration as a career in this sector?
Now all agreements have arbitration as a clause. So any dispute arises, goes for arbitration. Arbitration and litigation goes hand in hand. So anybody who does litigation does arbitration as well. Arbitration is more of a private litigation. So, but again, so far as the implementation of the arbitration award, initially thought to be very speedy, litigation efficiency in getting rights of the parties decided. But again, now you have 34, 37, so forth and so on. So anybody who does litigation does arbitration as well. I mean, when I was doing my law way back in 96, what we were taught in our law school about arbitration is entirely different than what we studied way back thereafter in London in our arbitration classes. Arbitrability, enforcement, international arbitration. Those are various very, very lucrative. So it all depends upon, as a lawyer, what kind of clients that you get.
Another question, so what is the normal time frame for housing project to be completed? With State Housing Authority not mentioned any date in the project templates.
So it depends from what is given in their brochure. But I mean, their resolution plans where they say after the project has been taken by after insolvency by a successful resolution applicant, it may vary from 5 years to 8 years. It depends upon what has been represented by the builder to the buyer. And for the delays, now you get your interest on whatever money that you.
Yes, any the last one to question participants? We are done with all the question. Any last questions? Can raise the hand or put the question in the chat box. Okay, so last question, like as a fresh lawyer, would you please enlighten the roadmap for arbitration? Okay, so last question, sir, over to you.
See, as a fresh lawyer, I would say if you have read the arbitration as a subject, you want to do arbitration, you go and work with a lawyer who has arbitration work. That's where you get to learn the nuances of arbitration. Because law is a subject where you acquire the theoretical knowledge from your books when you are studying, but ultimately it's a on the job learning. So I would suggest go for the best lawyer who is doing arbitration work and work in his chambers, work with him, and get the nuances.
Thank you, sir. Over to you, Viraj.
Thank you, sir. So, sir, with that, we just over this session, and so, sir, on behalf of the institution, I extend my deepest gratitude towards to you, not only just for accepting our invitation, but also for this wonderful session. It's a very fruitful in a very less time. So, thank you so much, sir. It show
Thank you
your
much.
all experience of it. So, thank you, sir. So on behalf of the Sambhav Initiative and Pro Bono India, I extend my deepest gratitude towards to you and for our invitation and this session. And thanks to all attendees whosoever join us today and make this session. Hope. Okay. Thank you, everyone. Once again, thank
Hope it's fruitful. Hope my young
Yes,
friends and my
sir.
young lawyers helps them in their future career. Thank you very much
Thank
for
you.
inviting.
Thank
It
you.
was a
Thank,
proud privilege. Thank you. Thank you.
thank
Thank
you.
you, Hiranshi ji. Thank you, Kalpesh ji.
Thank you.
Thank you very much. Thank you. Namaskar.
Everyone.